supporting the opposition, it is sufficient to say that you have defected from the party. This is the line of cases which have generally been there. But there is one unfortunate judgment of the Supreme Court which came from Karnataka, where the members of a particular party did not resign from their membership, independent parties. They started participating in the rallies of the opposition party, of the ruling party. They started attending their lectures, participating in their ceremonies. Some of them became cabinet ministers. But surprisingly, and I might say astonishingly, the Supreme Court said no, there is no defection because they have not given up their membership of the original party. That is the only one judgment which I may say with respect is an aberration as far as the 10th schedule is concerned. Now the other controversies as far as the thing is concerned, on the issue of the role of the speaker. On the role of the speaker. If you read all the important judgments are Jagjit Singh. The other very important judgment is Rana's case, a constitution bench where Justice P.K. Balasubramaniam has very elaborately discussed the importance of elections and so on and so forth. From the beginning, the speaker theoretically is expected to be a man of outstanding ability and impartiality. But by nature, unfortunately, he is a member of the ruling party. And in case after case, you find that his objectivity, his partiality is very, very evident. In the case of Rana, which came from where some BSP MLAs decided to go and told the government that look, we are supporting the ruling party. Now suppose they leave, they don't form the 1/3, right? So they get disqualified. Now how do you avoid the disqualification? Along with 13, 7 more people joined them and said that look, we are now 13 plus 37. We are more than 1/3 of the total strength of the BSP, and therefore there is no split as far as the schedule is concerned. What did the speaker do? He said that since now there are more than 13 plus 37, 50 people, I don't need to go into the disqualification. So he kept on postponing deciding on the disqualification. Now this is the most common feature where no decision is taken within any time limit. Finally, Justice P.K. Balasubramaniam said that not deciding on disqualification is an abdication of the speaker's duty. It is no concern of his whether their illegal act has been subsequently whitewashed or made valid because of the other people. He should have gone into disqualification and decided the matter. And what is most important is, by the time the matter came to the Supreme Court, the High Court also had delayed the matter. The Supreme Court says the High Court should not have been tardy. And then when the matter comes up, the members have only that particular assembly has only a few months to go. So Supreme Court takes upon itself and says, there is no point going back to the speaker. We here and now disqualify those members. It is a judgment of 2007 that merits reading. Now, the other point of the 10th schedule which you should read is the minority view in Quixote Holoan. All of us have heard of Quixote Holoan. It's a very interesting name which you can't really forget, Quixote Holoan. As you know, in that judgment, paragraph 7 said the decision of the speaker is final and will not be amenable to judicial review. This was taken up, and Quixote Holoan held that para 7 violated the basic structure because judicial review and judicial independence are part of basic structure. They struck down judicial 7. In fact, if you see the history of basic structure, majority of the cases have been struck down only because of taking away of judicial review. So anyway, what is important is the minority judgment of Justice Verma. Justice Sharma and Justice Verma were in the minority. Justice Verma goes into the pack in great detail and says this question of making the speaker's decision final is absurd. He is a member of the ruling party. How do you expect him to be independent and unbiased? He says you go to the elementary principles of administrative law, and he quotes the Latin maxim that no man can be a judge in his own cause. And what Justice Verma says is, if the fate of the assembly is going to be left in the hands of a partisan speaker, then the whole 10th schedule is bad, and he wanted to strike down the entire 10th schedule as being violative of the basic structure. The most important difficulty in all these judgments that I have studied is that the decision is not taken on time, and the decision if taken is completely partial. In fact, recently Justice Nariman said that there should be a time limit of 3 months to decide the issue. And this is one case where I personally speaking, either the constitution is amended or maybe it may require judicial gap filling to say whether it's the governor giving assent to the bill or the speaker deciding on disqualification, somewhere or the other there must be a time limit. When they framed the constitution, they said that look, these are all great eminent constitutional officers and they will do their duty in an expeditious manner.